apologies. And obviously, I can't see anybody. So I will start with introductions before we begin. I am the chair, Ladd Smith of the OPOC. We have our vice chair, Jenny Rose, attending as well. And we have Commissioner Luke Jasmine, who is also present. Absent, we have James Wilburn, and absent, Lily Navarrete. Also present from the OPO, we have Mr. Bart Logue. Missing from the OPO office is Deputy Ombudsman Luvi May Omana. She is on vacation. And of course, we have our wonderful administrative assistant, Christina Cody, who so graciously and patiently guided me through this. I'm a little bit rattled. I don't like to start a meeting late, but oh well. And then I believe we have our legal counsel, Mr. Tim Zamblin. Is that true?
Yes, that's correct.
Okay, thank you. And I don't have the agenda in front of me at the moment. I'm having to download that, but I do believe it has to do with approving the agenda for this evening. Commissioners, I know I have looked at it earlier. Commissioner Rose and Commissioner Luke, have you had a chance? I'm sorry, Commissioner Jasmine, have you had a chance to look at the agenda?
Yes.
Okay.
Yes.
Okay, and I'll entertain a motion to approve this evening's agenda.
I move that we. Oh, go
I'll
ahead,
second.
Luke.
You beat me to it, Jen.
Okay, I move to approve.
I second.
Okay, thank you. And then all those willing to approve this evening's agenda indicate by saying aye. Aye.
Aye.
And okay, now we'll go to the June 15th minutes. Attached to your agenda are the minutes for June 15th. If you could please take a glance, and I will also entertain a motion to approve the minutes from June 15th.
I was going to let Luke go first.
I'm sorry, I didn't quite catch that, Commissioner Rose.
Oh, well, I'll go ahead and make the motion to approve the June 15th minutes.
Okay, do I have a second?
I'll second. Was I on off of mute this whole time? I apologize. I'll second.
Okay, thank you. And all in favor of approving the June 15 minutes, indicate by saying aye. Aye.
Aye.
Okay, need the third commissioner to indicate by saying, or I've got two of us approving out of three.
Oh, no, I said aye.
Oh, I'm sorry. I apologize. I'm not hearing all that well. Okay, thank you. My apologies. Okay, we'll go into public forum. Do we have anyone signed up to speak this evening, Ms. Cody?
No, there's no additional signups.
You said there are none or two?
There are zero people to sign up.
Zero, thank you. Okay. All right, and we'll go, and I presume that we have Assistant Police Chief Lundgren. Is he with us this evening?
Answer.
Okay, thank you. Thank you, first of all, for being here this evening. Secondly, thank you very much for, I'm sorry, I apologize for the delay of the meeting, and I appreciate your patience. It's always a good thing to have someone from the Spokane Police Department, here at our meeting, able to help us with information and able to listen to questions or clarifications from commissioners. And I can't tell you how much I really, really appreciate you being here this evening. I know you have a home life, and this is taking a hit tonight. So again, thank you. And the purpose of your being here, I think you know, is to give us a briefing on the new legislation that came out of Olympia recently and went into effect. I believe it was late July or early August. Again, thank you for being here.
Thank you so much for having me. I can figure out how to share my screen. Bring up a PowerPoint if that is okay to help guide us through this conversation.
So up at the top, you'll see file, edit, and share. And below that, just do share content. And you should be able to pick what you'd like to see. There you go. Good job.
That's not what I want. Wrong one. Let's try this again.
If you want to email it to me, I can share it from my screen too if you'd like.
Also, at the very bottom, it says share content at the bottom of our screens. 3 in from the red X.
And Assistant Chief Lundgren, I have a clarifying question before you start, and let me know when you're ready for that question.
Right ahead.
Okay. Do you prefer, I'm really hoping to have some time for questions. Do you prefer, would you rather present the information and then take questions, or is it okay to ask questions as we go along? What is your preference?
Whatever you would prefer. I will take questions as we go if that's more, sometimes that's it flows a little better doing it that way, but I'm happy to.
Okay, so I think I hear you saying you're okay with questions as we go.
Sure.
And we don't have a lot of questions as we go, then we'll have some time after your presentation for questions.
Absolutely.
Okay, thank you, sir.
I think I finally cracked the code here, so.
Awesome.
Deal. Right. Okay, we'll start with House Bill 1310. Now the law, but it's easier to reference it by the bill numbers, I think. This impacted use of force, so it hit both our use of force and our de-escalation policies. And the big takeaways from this was one of the most substantial bills. Some of the big takeaways are to deadly force, where deadly force can only be used when necessary to protect against an imminent threat of serious physical injury or death. So that imminent threat of serious physical injury or death was certainly a large component of deadly force prior to the bill, but is a restriction, a slight restriction to the use of deadly force. The bigger change is in the physical force realm that is not deadly force. And what 1310 tells us is that you can protect against an imminent threat of bodily injury to the peace officer, another person, or the person against whom force is being used. Or you can use physical force when there's probable cause to make an arrest or to effect that arrest, prevent an escape, etc. So that is a large departure from the way things were prior to this bill taking effect. It also requires an officer to exhaust available and appropriate de-escalation tactics when using physical force, using the least amount of physical force necessary to overcome resistance under the circumstances, where prior to this bill, an officer was required to use reasonable force. The reasonable amount of force necessary that fit the situation. Another component of 1310, it added these considerations for people in different categories that we may want to consider our use of force as it pertains to someone being pregnant, if they're a minor, if there are children in the presence of the officers when the force is being used. These are all considerations that are added in part of this bill law. Excuse me. So when possible, we're required to exhaust available and appropriate de-escalation tactics prior to using any physical force. So this is time, distance, cover. This is calling for additional resources. We're very lucky to have, we have hostage negotiation team. We have special weapons and tactics team. We have our CIT trained officers as well as our BHU. So bringing in some of these specially trained officers to help facilitate these incidents, and they're going to last longer, but with the hope of not using force as frequently or reducing the amount of force that would be necessary under the circumstances. One thing that we did do prior to the law, and it's a tactical mandate now, is if you have multiple officers that are dealing with a situation, you designate one officer to communicate. I don't know if any of you have had the opportunity to participate in mock scenes out at the academy or during Citizens Academy. There's nothing more confusing than having 3 or 4 people yelling different things at you and expecting you to do something. It's very hard to understand what's being expected of you. So this clarifies by having one designated communicating officer. It mandates that we call for backup when encountering resistance, taking as much time as necessary without using force or weapons. So exceptional techniques leaving policy. Officers are required to terminate the use of physical force as a necessity for force ends. Use available and appropriate less lethal alternatives before using deadly force. And imminence is required for deadly force for both prongs of Tennessee versus Gardner. So most of the time when we talk about deadly force, we think of situations where the officer or someone in the immediate vicinity of the officer is being threatened in a lethal type of way, whether it's someone armed with a weapon that threatens an officer, whether it's someone shooting an officer trying to stab someone else, and it requires the officer's intervention, sometimes with the use of deadly force to bring that to a resolution. What this imminence requirement does is, under Tennessee Gardner, the second prong for Tennessee Gardner allows for, under federal law, for officers to use lethal force in very specific scenarios where someone is fleeing from them. We, in Washington, will retain very, very narrow sliver of that ability, and that will be cases. To give you an example, it'd be very rare. You respond to an active shooter at the mall. Several people have been shot. Officers arrive on scene. Suspect flees out the door, has the gun in their hand, and runs from the officer. That would be one example where imminence of threat of deadly force the imminence of the threat is present and would justify the possibility of an officer using deadly force to stop that person from continuing their active shooting rampage. It prohibits the officers from tactics that are prohibited by applicable department policy, by state law, or otherwise by law, except to protect his or her life or the life of another person from an imminent threat. So those, when we talk about exceptional techniques, if it's not a technique that we train that's in policy, only time that those techniques would be able to be used if they're outside of that policy, trained techniques would be in circumstances where there's an imminent threat to the life of the officer or someone else. And it also requires that we make less lethal alternatives reasonably available for officers to use. So one of the questions that comes up from time to time as we look at this new 1310 law is how will it affect our behavioral health unit and officers assisting mental health workers in situations involving people who are in crisis, who maybe have not committed a crime, but due to their behavior, maybe they're off of their medications. There's a perceived risk to the health worker who calls for our assistance to utilize the Involuntary Treatment Act to take them into custody. So officers have a new mandate that if there's no threat of imminent harm and no crime is being committed or has been committed or is about to be committed, that we will remove ourselves from the situation. So we're going to continue to go to all calls. We will assess the factors that present themselves, and then we will make a determination on what our involvement is going to be. We'll be careful in circumstances, for instance, where someone is indicating that they are going to harm themselves and they are home in their own home alone, and there's nobody else that's in danger. We're not going to push the envelope. We're not going to push that situation into potentially one where we have to use force. We will walk away. Now, if you change the circumstances slightly and say there's other people in the home, there's a threat, or there's some sort of imminent threat to somebody in the immediate environment, that changes things. But we're going to have to be very careful in the way that we approach non-criminal community type responses. We will still be able to enter into premises under exigent circumstances, as well as under the emergency aid doctrine. So if we go to a call for service and perhaps it's a domestic violence call, it sounded violent on the phone when the caller was on the phone with 911. Officers arrive on scene and they can see that there had been some sort of a struggle. Maybe they see blood. Nobody will come to the door. There has to be a specific suspicion that there is someone injured inside, specifically in that residence, and that we have to make entry in a very narrow fashion to find them. And it has to be because we have a legitimate concern for their well-being, and that we can't just walk away because perhaps they're injured and can't get to the door. So all law enforcement agencies in the state are required to submit our model policies to the Attorney General by December of 2022. The Attorney General will be publishing their model policies for our guidance on July 1st of 2022. We talked a little bit about the impact of use of force on non-criminal community caretaking functions and what that will look like. We will be eagerly awaiting the Attorney General guidance when it comes next year on some of these topics. For instance, we talk a lot about physical force. Physical force is talked about in the statute itself, but it's never defined. So it's not clear exactly what level of interaction they're considering physical force. We did receive some updated guidance from the Attorney General's office that they do not consider handcuffing to be use of force. That is helpful. And like I had said, if we respond to a situation where a subject poses no threat to anyone else other than themselves, we're gonna take a very careful approach. Now, if we can be in the area and communicate with that person safely and try to convince them to get down from the bridge railing or to come outside and speak with a mental health worker, we're going to continue to do that. But we're not going to force face-to-face, hands-on encounters under those circumstances. I think we've covered most of this. The only thing I'll add is that prior to leaving an ITA call, an Involuntary Treatment Act call, if an officer that's on scene determines that it's in our best interest to disengage, they're going to consult with the supervisor so that we can have a consistent approach on these and more than one person involved in that decision making. Terry stops. This is a big topic, and we could talk a long time about Terry stops. So the authority for officers to make Terry stops still exists under the federal law. What a Terry stop is a temporary detention that's investigative in nature in order to further investigate someone's involvement in possible criminal activity. Terry versus Ohio, which is the case that this is named after, it talks about reasonable suspicion being the threshold to engage with someone. Reasonable suspicion takes into account an officer's training and experience in recognizing all the characteristics of behavior that's attributed to criminal activity. So I think it's easiest if I give you two quick examples to try and explain when a Terry stop would be used. The first would be just a run-of-the-mill call for service. It could be any crime that's being reported by someone calling 911. They say they report that someone else has committed a crime. That person is still there. They provide a description of that person, a location where we need to respond. So officers respond to the area. As they're coming into the area where this crime supposedly occurred, we see someone who's leaving the area that matches that description. So what a Terry stop under federal law would allow us to do is to go and temporarily detain that person long enough for other officers to go and contact the complainant, witnesses, to look for evidence and to determine if a crime has occurred. We can still stop and talk to that person under the new law, but we can't use that physical force under Terry stops because reasonable suspicion does not reach the threshold of probable cause. There are two different standards. Probable cause means that more likely than not, someone has committed a crime. So it's that 51+% reasonable threshold that you believe someone's involved in a specific crime. So the difficulty becomes, and one real life example that ties into the one that I just provided is we'll just say a shoplifter. Shoplifters reported, officer comes into the area, sees someone that matches the suspect description that's coming from the area of the store. If that person doesn't want to stop and talk to us, unless we have developed probable cause for their arrest, we can't force them to stay while we gather the information like we normally would have. Another example will be on the self-initiated. So we talked about when officers are called to a specific place in the community on the report of a crime, but one of the other areas where Terry stops are very helpful and useful are in self-initiated contacts. So we use the CompStat model. We look for patterns of criminal behavior in certain areas. We look for trends. And if, for instance, we are having a number of burglaries in a neighborhood, we may assign that as a mission for officers to go when they have unallocated time, if they're not handling calls, to go through the area during the times when we're experiencing those crimes to see if they can either interdict someone or catch someone in the act, but also to just have an additional presence as a deterrence. Well, a Terry stop comes in very handy if you're working in an area that has higher burglaries than other areas of the city. You're driving along and someone on a bicycle with a backpack that's weighted down comes out of an alley in front of you. That might pique your suspicion, but you're not going to be to a level where you could make an arrest on probable cause with just that. So those are two really basic examples of why Terry stops and force are going to be impactful. If the officer is investigating a violent crime, so if we're responding to a homicide, let's say, and we have a suspect that's leaving the area, the other prong besides probable cause that will allow us to use physical force to detain someone is the imminent threat prong. So either one of those or both can be used to justify the use of physical force to detain someone. So the more serious the crime, the more imminent the threat is, of letting the suspect simply leave the area before we can determine whether or not a crime has occurred. I see I've got red dots over here. Are there questions in the queue, or am I free to keep going?
Does anybody have any questions for the assistant chief?
Not at this time.
Well, so you have more?
More slides?
Yeah.
Yes, sir. Yeah, there's
I'll have my questions to the end.
okay. Report writing. So when officers use force, they will provide what's called a Graham statement that includes Graham factors in their report. And the Graham factors are the severity of the crime involved, immediate threat or risk, and then the flight or resistance of the suspect. So all of those factors need to be laid out in the report so that the officer can explain why they use the force that they use. With the new law, we're going to add reasonable care factors to the list of the other three. So the officers will now be also talking about exhausting the available and appropriate de-escalation tactics and what that looked like, how they use the least amount of force necessary under the circumstances. So it might include information as to how they arrived at using the specific tool that they did or technique, and to the exclusion of others, and then how they terminated the use of force as soon as it was as a necessity for force ended. Senate Bill 5066, duty to intervene. So we had this in our policy already upon the passage of this law. We updated our policy to include specific language that was used by the legislature. What this does is it creates a duty to render first aid to people after we use force. It requires anyone who witnesses another law enforcement officer using or attempting to use excessive force to intervene and end the use of excessive force, and to report it to their supervisor. It does also prohibit law enforcement agencies from retaliating from anyone for either reporting excessive force or intervening. So one of the key considerations listed here at the bottom is the perspective of excessive force is based on the observing officer and the policy of the observing officer's agency. So there is a little bit of ambiguity as to how that perception would take place. It also requires that departments report certain activities such as failure to intervene or failure to report to the Criminal Justice Training Commission, who's responsible for all law enforcement commissions for local agencies and sheriff's departments in the state. The CJTC will be developing and providing duty to intervene training that will be put out to all commissioned officers statewide by December 31st of 2023. So to House Bill 1054 that deals with tactics, this, as you can see, talks about uniform regulations, vehicle pursuits, control techniques and devices, de-escalation, and use of force policies are all modified as a result. Prohibits the neck restraint or chokeholds used by officers. So this will no longer be an authorized technique. So any vascular neck restraint or similar restraint or other tactic where pressure is applied to the neck for the purpose of constricting blood flow is prohibited. It prohibits no-knock warrants. No-knock warrants are not anything that we used. And CJTC will develop a model policy for the training use of canine teams. Earlier on in the reform discussions, there was talk of legislating some restrictions on canines. Compromise arose during the process that CJTC is going to just look at the model policy and push that out to the state agencies. Tear gas is prohibited in most circumstances. Tear gas isn't something that we used on, very frequently. Primarily, our agencies has used tear gas on barricaded subjects to try and get people who are armed or dangerous, who are barricaded in a building or a home, to come out to us rather than us going into them. The new law allows officers to use tear gas during certain circumstances of riots, for barricaded subjects and for hostage situations. But there are caveats. You have to exhaust, for the barricaded subjects, you have to exhaust available and appropriate alternatives. There has to be supervising officer authorization. You have to announce the intent to use the tear gas prior to deployment. And you have to allow sufficient time and space for the subjects to comply. Prior to deploying tear gas for a riot outside of a correctional facility. So if we were to have some civil disorder and wanted to use tear gas for a riot, whether it be downtown or anywhere else in the city, we would need the express authorization of the highest elected official. So we would need the mayor's authorization to do that at this point forward. We talked about exhausting all alternatives available and appropriate under the circumstances and announcing our intention. And this is just some of the language taken right out of the law. So it also requires that we are reasonably identifiable. So when we're in uniform, whether we have a name tag or a badge with a number, with a personnel number on it, there has to be something on uniformed personnel that specifically indicates who they are. It's identifiable to them so that members of the public can, in a later time, if they need to, be able to identify who it was that they had an interaction with. It prohibits an officer from firing a weapon at a moving vehicle. Again, there's a caveat there. If the driver or a passenger is creating an imminent threat by firing a weapon at officers, they can fire at a person that's in a vehicle. or if the vehicle is specifically being used as a deadly weapon and there's no other reasonable means to avoid potential serious harm. So you may have seen cases around the world and even here domestically around the United States where people will drive a vehicle directly into a crowd of people. That would be one example where force would be allowable, deadly force would be allowable against the vehicle. It prohibits the use or acquisition of military equipment. And military equipment isn't just equipment that is provided by the military. It really is a list of different tools that we have. Well, a bunch of tools that exist. Some of them that I don't think ever have been used by law enforcement agencies, but some of them have been. So regardless of where they were sourced, whether they were bought from a civilian, your normal channels of acquisition, or through a program with the government to provide military equipment to law enforcement agencies, if it's any of these items here that you see, they're no longer authorized. One item of note is the 50 caliber or greater firearms. That is one of the areas that is a little bit that we need clarification on. A firearm, as it's defined in the RCW, a firearm uses a powder, either black powder or smokeless powder, to propel a projectile. And so a lot of our less lethal tools, both 12 gauge shotgun is able to deliver a beanbag round, a sock beanbag round. And then we have 40 millimeter launchers that can launch foam projectiles that are also a less lethal tool. But both of their bores are larger than 50 caliber. So we've sought out legal opinions from city legal, and then we've also had the benefit of seeing legal opinions from all across the state, and they're mixed. You have a lot of attorneys that say that it's very specifically called out 50 caliber or greater, and it's a firearm, so you can't use anything regardless of it's less lethal or not. And then you have others that say that the intent of the legislator and the emphasis on the use of less lethal tools leads them to believe that the 50 caliber or greater does not apply to less lethal tools, even if they are delivered technically by a firearm. So the jury's still out. We have elected to take those back and only use those less lethal tools that we have that don't violate this provision until we get further guidance. And then any of the items that we do have or in possession of, we have to return or destroy. So our SWAT team, the weapon that the long gun that our SWAT team has issued was a semi-automatic long gun already. However, many years ago, there were fully automatic selector switch carbines that preceded those. We had some older rifles that had the ability to fire full auto, and we had to destroy those. And suppressors are not included in the definition of military equipment. So the suppressors that are on rifles help to save the hearing of officers and anybody in close proximity in the event that they have to fire their rifles, particularly if they have to fire them in an indoor. Vehicle pursuits. Our pursuit policy is actually a little bit more restrictive than the new state policy. This really isn't going to impact us much. We recognize with the level of traffic that's in the city and the driving behavior of some of the fleeing suspects that we pursue that long before the legislation came into effect, we had restricted and then restricted again further restricted circumstances that we would allow officers to pursue, just due to the danger to them as well as to the public. Here's some of the crimes that would allow for a pursuit under state law. So this is a change, and this is something that will be new for SPD. Officers need to receive authorization from a supervising officer prior to engaging in a pursuit. So that is new. And what you're seeing here are a list of factors that were captured in our policy before. You know, our policy in a nutshell, there were specific criteria that allow an officer to engage in a pursuit. And then once that pursuit begins, there's a continual responsibility to weigh the risks caused by the pursuit and the officer and the suspects driving against the threat that that person is going to escape. So we were constantly weighing that. We had supervisors who it was required the supervisors would monitor pursuits and oftentimes would terminate those pursuits if the officer didn't terminate them themselves. So the stop sticks. Does everybody know what a stop stick is?
No.
So a stop stick is a device. It's a piece of plastic. It's triangular. It's a long tube that's triangular on the end, and it sits inside of a nylon sleeve. So you fold these, I think it's 3, maybe 4 foot sections of this tube. It sits in this nylon, and it has a reel with a cord. And you deploy it in front of a vehicle that's trying to get away from officers, and it has very small diameter spines that poke through tires and slowly release the air in a kind of a safe and controlled manner. So it deflates the tire, and it helps to get that person stopped in a safe manner and to control the speeds ability of a fleeing vehicle. So we're going to continue to be able to use the stop sticks, and under certain circumstances, they're certainly a great tool. However, they are very dangerous for officers to deploy. There have been officers all across the country who have been struck and killed by either suspect vehicles or officer vehicles trying to position themselves ahead of a pursuit in order to deploy the spike strips or stop sticks. We are cautioning officers to only use them in appropriate circumstances where it's safe for the officer that's deploying them. House Bill 1109 was it provided some additional obligations in investigation of sexual assault or victim notification. So we've modified our crime victim card to include some of this information, and then it also requires notifications by the prosecutor to update a victim on their case. So some of this applies to law enforcement. Much of it is outside of law enforcement. So some rights for minors, responsibility of the prosecutor to provide remote video testimony. We would be required to provide interpreter services where necessary, so that we can gather facts through our investigation. So 5051, Senate Bill 5051, covers all the state oversight and accountability of peace officers. So this hit a lot of our policies as well. One thing that I don't think any of us anticipated or realized when following all the discussion on the reserve officers or the discussion on the accountability of police officers is that the definition of reserve officer changed, and they included all specially commissioned and limited authority officers in the same section as reserve officers. And why that's important is we had specially commissioned, limited commissioned officers that were employees of other entities. So for instance, the STA had limited authority, limited police authority for their security. This allowed them to write misdemeanor citations for things such as unlawful bus conduct or trespassing without police response. However, by including that in the reserve officer category, it also subjected all of these limited commissioned officers to the same criteria and the same standards that full-time officers were placed under. So it became untenable for us to authorize limited commission outside of our own employees because of the supervisory requirements and the reporting requirements at CJTC. There's just no way that we would be able to gather that information with any level of confidence, and we're mandated to do it with some pretty hefty civil penalties if we don't. So one new aspect of this particular bill is that CJTC may conduct investigations. So this is another avenue that anyone can go and file a complaint against a commissioned officer in the state of Washington. CJTC has the authority to suspend or revoke a peace officer's commission in the state. So it's very, the stakes are very high if they conduct an investigation of improper conduct and have a negative finding for a peace officer.
Assistant Chief, I believe Commissioner Rose has a question. Jenny?
Yes.
Thank you. So that last little bit about the reserve officers, I know in Spokane Public Schools, our reserve officers were all commissioned. So it's my understanding now that they will not be commissioned officers. Is that correct?
That is correct, and that began to take place before any of this legislation.
Okay.
Yeah, what we had planned, what the district desired, and what we had planned to do was to have the security manager was going to be the sole commissioned employee of the district. He's a former law enforcement officer, and it just made sense that they continue to have at least one person that would be able to do these criminal investigations. However, yeah, you're absolutely right. Once this passed and went into effect, we're no longer able to do that as much as we would like to.
Do you know if there's still a contract between the Spokane Police Department and the Spokane Public Schools in regards to because there used to be a contract, but I'm going to assume that can no longer be, and it would just talk about the commissioned officers and the training and things like that. But I'm going to assume that is no longer going to be available.
Yes, there was. You're absolutely right. There was a contract, and it detailed the limited commission. And actually, the school district was in a unique position. They had a special commission, so they were not limited to misdemeanors. They were dealing with vulnerable population, with juveniles, and as such, they were afforded the opportunity to investigate felonies. Many of the security that continue to work for the district were former law enforcement officers, former reserve officers who had been through a full academy and had a better understanding than most of the limited commission that we had authorized for other entities. But yeah, that MOU detailed their authority, and certainly that portion of it would go away. There isn't anything that precludes us, if it were appropriate, from providing them some sort of training, but it just wouldn't be for the enforcement of criminal law.
Okay, thank you.
You bet. So 5051 says that the commission must deny or revoke the certification of an officer or applicant for the following, which would be a conviction of a felony offense, a gross misdemeanor DV offense, an offense with sexual motivation, an offense under 9A44, which is some other sexual offenses. For federal or out-of-state offenses comparable to those other listed offenses, if an officer didn't disclose an offense at the time of application and it later becomes discovered, they're going to deny or revoke that certification. The officer was a certified peace officer or corrections officer at the time of the offense, and the offense is not one for which the officer was granted a full and unconditional pardon, and the offense was not adjudicated as a juvenile and the record sealed. So there's several circumstances where officers are subject to losing their commission. So if an officer has been terminated by the employing agency and after engaging in or is found by a court to have engaged in the use of force that resulted in death or serious injury and the use of force violated the law, if an officer has been terminated by the employing agency after witnessing or being found by a court to have witnessed another officer's use of excessive force and was in a position to intervene and didn't or failed to report the use of excessive force in accordance with policy and procedures, these are all career ending or at least certification ending violations. If the employee has been terminated by the employing agency after knowingly making or being found by a court to have knowingly made misleading, deceptive, untrue, or fraudulent representations in the practice of being a peace officer or corrections officer. So perjury, filing false police reports, dishonesty is going to be something that's going to get your certification taken away. Or if an officer is prohibited from possessing weapons by state or federal law or by a permanent court order. So official misconduct, engaging in use of force that could reasonably be expected to cause physical injury and the use of force violated the law or policy of the officer's employer, sexual harassment, fraud or misrepresentations, engaged in conduct including but not limited to verbal statements, writings, online posts, recordings, gestures involving prejudice or discrimination against a person on the basis of race, religion, creed, color, natural origin, immigration status, etc. So all of those things are CJTC has the authority to revoke commissions. Expands requirements related to pre-hire background checks. This really doesn't impact our process at all. Our process was pretty very, very thorough to begin with, just changing up some of the forms that we'll be using in our process. Within 15 days of an occurrence of any of the described, any death or serious injury caused by the use of force of an officer, anytime an officer has been charged with a crime, we need to reach out to CJTC and let them know. Requires law enforcement and corrections agency to retain personnel records for the duration of the officer's employment plus a minimum of 10 years thereafter. So that's longer than we kept records. And it casts a pretty wide net in the types of records that must be retained. I think we can all agree that this is going to put CJTC in a very important role when it comes to oversight. It's going to be one more layer of oversight that's much more enhanced than it was before. It requires the employee agency to conduct investigations if the totality of the circumstance supports the conclusion that the officer resigned or retired in anticipation of discipline. So before an officer had violated a policy, we'd begin an IA investigation. If that person quit or retired, we no longer have the hook to tell them they have to come back and participate in an interview like our employees. This is saying, regardless of that, you follow your investigative processes and you do as much as you can, even if you can't get the statement of the involved officer. This hasn't changed. We always have been reporting anybody that leaves for any reason. If somebody resigns, they retire, they may be a model employee. We let CJTC know within 15 days. And the purpose of that is after 2 years, they haven't had the upgraded training that's required. There's training requirements annually to keep your certification. So after a couple of years, if they were to be hired back as a police officer, they'd have to go through the academy again. So they keep track of the employment status of all commissioned officers. And then we also now will report within 15 days of any initial disciplinary decision by our agency for alleged behavior or conduct by an officer that is non-criminal may result in revocation of certification pursuant to RCW 4.5. Any pending criminal charges, any convictions, pleas, or other case dispositions need to be reported immediately to their agency. House Bill 1088 covers Brady material. I don't know if you're all familiar with Brady v. Maryland, which is, it's a court case. The crux of the matter is that anyone who's before the court who's being accused of a crime has certain rights to know if an officer who's going to be a witness in a proceeding has a history of being dishonest, history of being biased or prejudiced, history of deceptive acts. So this House Bill 1088, it outlines the process for which agencies are supposed to provide information or need to provide information to the prosecuting attorney's office, so that they're aware and that they can provide that to defense counsel when it's appropriate. Plus, if we're going to hire lateral officers or officers who were police officers in the past, it requires that we investigate whether or not they have ever been subject to a Brady or potential impeachment disclosure type of list in the past in another jurisdiction. House Bill 1140 is pretty interesting. It cloaks juveniles with some extra protections under the law. They have now will be required to have access 24 hours a day to an attorney prior to officers asking any questions or conducting an investigation. Now there are some small carve outs if there's a case where life is in danger. You need to talk to a juvenile immediately, because if we don't talk to this person, they have information that will help us to save someone's life, then we would be able to circumvent contacting an attorney. But as you can see on the slide, we don't have the ability or the infrastructure at this time for this 24-hour availability of defense attorneys to talk to the juvenile clients that we contact. So prior to a juvenile waiving any constitutional right, we have to request the juvenile consent to any evidentiary search, their person, property, dwelling, or vehicle. If we detain detain a vehicle based on probable cause of involvement in criminal activity, or if we question a juvenile during a custodial interrogation. All these things trigger us contacting an attorney to speak to the juvenile. And the interesting thing is the juvenile, even if they say they don't want to talk to an attorney, they can't waive this right. Juvenile may be questioned without an attorney, and we talked about this, if they're a victim of trafficking, if there's information sought that's necessary to protect the individual's life from that delay to allow legal consultation would be the protection of an individual's life from an event, or questioning by law enforcement officers limited to matters reasonably expected to obtain information necessary to protect an individual's life from an event. And it also provides a protection that if officers interview or found to have interviewed in violation of this section, basically throws that statement out and can be used in a criminal trial. So we implemented a policy in 2020 referencing the reading of juvenile Miranda warnings. These juvenile Miranda warnings are now in the process of being revised to be consistent with new legislation. Juvenile DUIs. Juveniles do not need to be provided with an attorney prior to field sobriety tests, so we did receive that clarification. There's a new mandate. I'm sorry.
I'm sorry. Just a quick. I apologize for interrupting. Just curious as to what do you think, or why do you think the legislature passed this House bill? What prompted or precipitated the need for this change, in your opinion?
My opinion would be that both on the culpability scale, juveniles don't have a fully formed brain. Their choices are not necessarily always well thought out, so they have an elevated chance for encountering law enforcement and enforcement situations. And then you couple that with kind of a lack of sophistication in the legal system, as a generalization anyway. It is, I think, a skilled police officer who's used to interviewing people who are very good at keeping information from them, potentially could elicit incriminating information from a juvenile more easily than they would. So I think that perhaps that was what they were driving at.
Mm-hmm. Okay, thank you.
That's just speculation. You're welcome.
Mm-hmm.
So, House Bill 1223 requires recording of custodial interrogations. So, our body cameras that we have are really going to save the day in this regard. So, for patrol officers who are doing interrogation, we don't have to acquire a bunch of extra equipment or try to figure out how to do these recorded interviews. We're going to be able to audio and visually record them on our body cameras. There will be some additional. We'll have to get some more body cameras for some of our investigators that aren't all outfitted. But it requires that all custodial interrogation of any adult for a felony offense or juvenile for any offense be electronically recorded. There's limited exceptions, again, much like the other law, but they're very limited. It limits the admissibility of the statements requiring electronic recording where there isn't an electronic recording made. And it requires officers to prepare a report explaining the decision to interview a person outside of a place of detention. So the requirement for audio and video recording is at a jail, a police or sheriff's station, a holding cell, or a correctional or detention facility. It requires a minimum of audio recording, but for the purpose of custodial interrogation at any other place of detention. So police vehicles are included, schools are included when it's a juvenile. So most of our interrogations are going to be recorded. lot of changes to civil protection orders. Much of it doesn't have a lot to do with police. Our extreme risk protection orders, DV orders, and concealed pistol license policies were all impacted. There's some timeline requirements of when the subject and ERPO must surrender their firearm. There's more stringent service process requirements for law enforcement and timelines. There's duties for our records division on the timelines for data entry. DV orders must be entered immediately into WASIC when we get them. I'm not going to read the process for extreme risk protection orders. These orders are granted by the court in cases where there is an imminent threat that someone is going to be violence. If a family can come forward and solicit the court saying that somebody is in a mental health crisis, they have access to weapons, and they're afraid that they're going to go. They've made statements. They're afraid they're going to go shoot up their workplace or a school or something of that nature. They go before the court, get this order, and then law enforcement must act quickly to assist with the serving of that. If for some reason we can't find somebody, can't find them within 10 days, then there's a requirement that we let the petitioner know so they're aware and kept in the loop. And if the protected person is there when we're serving them, then we're required to take reasonable steps to try and protect and separate the parties. Unless you're interested in the nuts and bolts of some of this order stuff, it really doesn't. I don't think it'd be as of interest to you unless you'd like me to continue with some of the details on this. There are 400 pages or so of changes to all the different orders and categories of orders in the state.
I would suspect we probably don't need that information at this point.
Okay. It structured the process for the surrender of firearms where that is required for certain orders, including proposed. Yeah, let's go to Senate or House Bill 5038, and it deals with open carry of firearms. Makes it unlawful for any person to knowingly open carry a firearm or other weapon while knowingly at any permitted demonstration. Interesting thing about this particular provision is that if there is a demonstration that hasn't been permitted by the city or by the police department, but is large enough, which I believe is 15 or more people, it allows for the chief of police to deem it a permitted assembly or permitted demonstration, and upon that designation, then it precludes people from being able to carry open carry firearms within 250 feet of that demonstration. Professional development. The CJTC is going to grant $60,000 to 2 law enforcement agencies, one on this side of the state, one on the other side of the state. So we're going to reference this grant in the hopes to be able to put that money to use implementing these reforms. The Blake Bill. So this is the rework of the Controlled Substance Act. As you might know, the Blake decision made felony possession of all the hard drugs such as methamphetamine, heroin, fentanyl. Threw that law out based on lack of knowledge by the a lack of a knowledge requirement. So the legislature took another crack at it, and what they came up with is for the first two violations of this law, it's not a criminal referral. It requires officers to provide a referral to a drug treatment facility, and then upon the third contact by law enforcement, when someone is possessing one of these drugs, it will become a misdemeanor offense. It doesn't require that you arrest them for the misdemeanor offense, and actually encourages continual referrals and deferment of any criminal culpability for drug possession. But we're working through that. We will need, because it's a misdemeanor offense, we will need the city council's cooperation in implementing a city municipal code to mirror this law here locally, so that we can send these cases through the municipal. I-940 seems like old hat. It seems like a million years ago now, but the Law Enforcement and Training and Community Safety Act required all law enforcement officers to undergo 40 hours of training related to violence, de-escalation, and mental health. The required training is split into 24-hour patrol tactics course and a 16-hour implicit and explicit bias training. BLIA students, so our new hires that are going through the academy, are getting this curriculum in the academy. SPD currently has 8 people who are certified in patrol tactics instructors, and they are able to weave this training into our in-service trainings. We have until 2028 to complete the training per the law. This is nuanced, but somewhat significant in that a mental health order will be entered into WASC as a warrant, which means when officers do a name check on someone, it appears that they have a warrant for this mental health order. So we're going to have to be very careful that we don't mistake them for a criminal warrant, and particularly with the new use of force restrictions on arrests and non-arrest situations. So I think that ends our slideshow. If you have any questions.
Commissioners, any questions or clarifications?
Rose.
Yes.
I was just going to ask if there are a couple of things. One, has any training been started for our officers on this, or any specific plan that's been, implemented to get the training? I know some of the training doesn't have to be complete till like 2023, which seems like a long time to me, but I was just curious about starting the training on some of these changes.
Absolutely, that's a great question. We had an in-service that was underway when the governor signed these into law, and so it was an emergency vehicle operation. In-service was the topic, so we were learning and refreshing on the driving and operation of emergency vehicles, but we were able to take what we could at that time and discuss some of the reforms. To be completely honest, the magnitude of the reforms was so overwhelming that it took weeks to try and compile and to go through and make heads or tails of some of the reforms, how we were going to implement training, how we're going to do things differently, and then how it touched all the different policies to make sure that we updated all the appropriate policies for each piece of legislation. Do you have another in-service that will be starting, I believe, in September? It's our fall in-service, and there's going to be extensive reality-based training that's going to incorporate aspects, particularly surrounding some of the more high high liability aspects of legislation, use of force, detentions, de-escalation, all these new requirements. We've been doing de-escalation training, reality-based training for quite some time, but we're going to be fine-tuning some of the scenarios to really get multiple learning points out of each scenario as it relates to legislation.
Speaking of de-escalation, now that the neck restraint has been taken away, what have officers been, well, I know there's other tools they can use, but has there been any specific tool that they've been told, or does it just depend on the circumstance of what's going on?
It really is circumstance dependent. The neck restraint requires you to be very close to somebody.
Right.
So, the taser isn't 100% effective, but it's a pretty effective tool, and it quickly ends. When it is effective, it brings things to an end very quickly. But tasers are usually used when you have a little bit more space and time. There's OC pepper spray can be used by officers, but each of these tools, there's just a lot of different factors that the officer has to weigh, and just try to make the most appropriate force choice under the circumstances. So I don't know if there's a specific go-to technique that will replace the neck restraint, but certainly each case is going to be factored in.
Okay, thank you.
I did. Thank you for the presentation. I did have a few questions. One is around, there's quite a bit of misinformation going around, and I know as you all try to figure out how you're going to respond and how you're going to train your own force, are there any plans to combat the misinformation that's happening in our community currently?
Yeah, that's a great question. So, as an agency, we're trying to communicate in a thoughtful way with the community, and as you probably noticed from the presentation, a lot of these changes, it's very nuanced. You have to get it's almost best explained through examples and scenarios. So one piece of misinformation that we have addressed widely as widely as we can is that there was a thought that we were going to stop going to certain types of calls. That people are going to call and we're going to say we're not coming. And I think that the chief and Julie Humphreys and some of our command staff have done a good job of communicating out to the public and saying, no, that's not what we're going to do. However, when we arrive, we're going to have to weigh things a little differently than we did, and it may require that we leave sooner than we would have before. But we're not going to just categorically say that this type of crime we're not ever coming again, or this type of situation we're never coming again, because it's more nuanced than that. But the sheer volume of the changes, it really requires a presentation like this to different groups, and there has been this training has gone out to our department and then some of our partners as well. The fire department, for instance, was concerned about how the changes were going to impact our relationship and how we would work together. So a similar presentation was provided to fire leadership as well. So I'd be open to suggestions on how to accomplish that messaging the best way possible. But we certainly want the public to understand. And, when something changes, if you are aware of it ahead of time, you might be disappointed or you might be happy, either one. But if someone doesn't tell you and something changes, your expectations weren't set the way that, they weren't properly set. People tend to be very upset about that. So it's a good point.
I did have a few questions, but I also wanted to give time to anybody else who.
I think I'll piggyback on what you just said, Commissioner Jasmine, is the messaging that I was seeing on TV and many of our Spokane citizens were also seeing on TV is different law enforcement agencies coming together and messaging that this is a crisis, that this is, the sky is falling, and be afraid, be terrified that the police will not be there for you. And then when you look at some of these neighbor apps on neighborhood or whatever it's called, Your Neighbor or something like that, you look at some of the threads that are happening there, and then people are just have some really negative. They picked up on what I perceive to be negativity and the messaging on TV from the chief and from others about how horrible this is. So how can you message to the community that indeed they are going to get service, that there is how can they feel safe after that initial messaging is where my concern is.
So anytime that you get that many law enforcement executives that are responsible for their own counties, their own cities, and you have a press conference, everybody has a little bit different perspective on how it's going to impact them. I thought that I did watch that press conference. I thought, there's certainly there were concerns that were expressed by one gentleman, a sheriff. I can't remember which county that he represented, but they have a jail that they operate, and so he had concerns that weren't our concerns, but was what was on his mind. I thought the chief did a very, very good job in representing Spokane. In his statements, I think he was fact based, and the reality is these are going to be significant changes in some areas, and it's going to change what people will see. It's not the sky is falling. It's not that the city's not going to be safe. But having dealt with the victims of crime, particularly property crime, for almost 24 years now, there's a frustration when people are victimized, and there's a frustration even before this legislation that there isn't enough done by law enforcement. Why are you not writing 7 search warrants so that you can track down my stolen property? We don't have the personnel to do that. Well, that just wasn't an acceptable answer. So when you start talking about the change to Terry and the use of force and the changes to detention, we're going to have to evolve. We're going to have to come up with new and better ways of doing our job, but it is going to be a significant change. And I'll tell you, the first time that somebody has lost property and they find the suspect and they tell us that's the guy right there, and we don't have probable cause and we have to let him walk away, I think you can imagine the level of frustration the community is going to have it as. So it's important that we message in a way that doesn't scare the community. It's very honest and upfront and prepares them and sets the expectation so they understand the rules that we are going to be playing by. And we're going to play the game the best way we can, but we got to play by the rule book. And so I think that's how you do the effective messaging. It's not meant to cause fear or elicit fear. Nobody came into this job on our police department. Nobody came in to not go out and try to make some sort of a difference, to not make the community safer. I have worked in 24 years. I've worked with some of the most amazing individuals I've ever met. I mean, people that will put themselves in harm's way for a stranger, and they're not the kind of people that are going to just turn their back on the community and not do their best. But I do think have to do good job of saying how things that are going to change are changing before the community experiences the change and then turns to us and thinks that we're somehow not doing our jobs the way that we're supposed to.
Well, the message you just presented to us here a moment ago, or just a few seconds ago, is that nobody in the Spokane Police Department is in the department to make people miserable. That's not. I understand that, and if only, and I know we could do if onlys all night long, but if only that kind of messaging was coupled with, my God, I will concede 100%. I cannot believe the number of changes that the legislature has put upon law enforcement I think, for good intentions, but any profession and the professional who's in that profession being hammered with all of these changes, I can only imagine the challenging feeling of how much your job is going to change through time. But I would also like to believe that data is going to be collected on these changes. And hopefully in 6 months to a year, we can look back and maybe discover that it wasn't as bad as we thought it was going to be on some of these. And some silver linings have come out or will come out that will put the police department, at ease. And trust me, I know I'm a lay person, and I don't even begin to pretend I understand what you're going through, because I certainly don't. But it's got to feel overwhelming. But hopefully we will find some goodness out of this. I guess maybe my last question would be, what is the one or two pieces of legislation that makes it hard for you to sleep at night? And what are one or two that you think, hey, you know what? I think this was a good thing. I think this was a good change.
Okay. So I think probably the biggest concern I have in my position, I look out after the welfare of the community, and I look out after the welfare of our officers. And so it's not necessarily the specific changes, it's that an officer is going to hesitate because they don't know what they are supposed to do or where their authority ends or where it begins. And as a result of hesitating, that somebody gets hurt. That's always, before this legislation, that's what keeps me up at night, is an officer getting hurt, a community member getting hurt. Those are the things that almost everything else, and Tim could tell you, sometimes things get broken and end up paying out claims or whatever. That sort of thing we can learn from and move forward. But the violence that officers sometimes encounter, it happens quickly, and the people who inflict violence, the type of people who inflict violence on community, they inflict violence on law enforcement officers. Some of them are very savvy in the way that they cloak their intentions. And so as we're trying to de-escalate and we're trying to deal with this very, very small population of people who are truly dangerous to everyone, that they may hesitate, that they may not grab onto somebody quick enough. They may not take control enough of a situation. And that's really where it is. It's a vague concern. It's not something that I can point specifically to chapter and verse of a specific law, but it has to do with the changes and some of the new requirements surrounding detentions and force. Good changes. I think, SPD had implemented versions of some of these provisions ahead of the state, and we endorse all of those. I think, I really think that the vehicle pursuits, it's just an area where, in very, very narrow circumstances, it's a good thing to do, to go and pursuing it at high speeds. You have a kidnapping and there's a kidnapped person in the car. You have someone that killed somebody and you have no idea who it is. You have really serious crimes that justify that level of pursuit. But the danger to the community, the danger to the officer, the danger to the suspect for every minute that those things go on, I think that there were some good changes made to restrict those statewide. I think it's going to make the community safer.
Okay. Thank you. Commissioner Jasmine may have more questions, or Commissioner Rose. But I will just finish my time with you is to say a big thank you for creating some clarity and having a really objective presentation. A lot of information, and I'm hoping that once we post this onto the OPO website, that other citizens will be able to watch this presentation. So please know that there's an outreach that goes beyond just the few of us here tonight, but hopefully we'll reach other people. So again, thank you so much, and I'll go back to the other two commissioners.
So a suggestion which Commissioner just talked about is the neighborhood app. If there was some type of messaging that could be done through there, I would strongly encourage that, or even just a link to information so that people can get accurate information. The next question that I have is not necessarily based off of the presentation that you gave, but more so based off of community concern that I've been hearing for the neighborhoods here in the Northeast. It's in regards to more police being stationed downtown versus the other neighborhoods. And I know in District 1, where I'm at, there is a high level of property crime, or at least the residents feel as though there's a high level of property crime and just crime in general. So are there any conversations about relooking at where police will be put? And I mean, will we see, I guess that's my question. Is there any indication that they'll relook at that?
So that's always something that we're weighing, how we're going to allocate resources. We had a discussion in our senior staff meeting last week about this very topic and prioritizing where officers can go. And not surprisingly, everybody, most people want to see more officers in the neighborhood. They want to see more officers where they work, in school, and that sort of thing. And the feeling of safety that those patrols bring. One thing that I will say is that the downtown precinct has increased staffing. But when I started in 1997, there used to be an early and a late shift that worked downtown. They didn't have a precinct per se, but they had designated patrol teams. Their coverage, I want to say, was 18 to maybe even 20 hours a day covered by this early and late David for downtown sectors. There were more personnel down there then than there are now. So by comparison, as the city has grown, although recently allocating more people in the downtown precinct, there is actually fewer than there were when I started my career. One of the interesting things about downtown that I hadn't really thought about until I got into law enforcement was, you look at the city of Spokane, it's 215, 220,000 people roughly. But downtown, during the day, many people from outside the community go to work, they go to eat, they go to work out, they go to get a doctor's appointment. So the population of that small area swells considerably during the day hours. That's one of the reasons why dedicated precinct model in the downtown core is really effective. But I would like to have more officers in patrol than we currently do. I would like to have more NROs. There are detective and investigative assignments. I'd like to have additional assets. And we have positions that we're in the process of filling. So we're not completely full to our authorized strength, and that'll alleviate some of the pressure that we're feeling right now. But between the growth through the levy and adding 20 new positions and accompanied by attrition, just trying to keep up with that. And we've grown every year for the past, I think, 8 years. There's been at least 2, 3, 4 officers added per year. And so trying to keep up with that growth and attrition has been a challenge. But I completely agree with you. We're talking about ways to bolster our patrol staffing procurement. So we're hopeful that we'll be able to do that here shortly.
Okay. I have many more questions, but I'll just ask one more. So, domestic violence. So, especially in the Northeast, that is a huge issue. And I'm sure you know the statistics really well. What do you see being done by the police department to, help curb the rates of domestic violence that we're seeing, specifically in the Northeast Spokane?
So that's an excellent question. Domestic violence in Washington is much higher than I like to see it, and in Spokane, it's high for Washington. So it is of utmost concern. One of the things that we've done is we have increased staffing to our domestic violence unit, work in close coordination and work closely with YWCA. They provide a lot of service provision that we can't do as a law enforcement agency. We have officers that are assigned to go to the jail and contact people who've been arrested, and we're able to ascertain additional information, to provide them with information, and be a little bit more involved, particularly on misdemeanor offenses, than we had the capacity to do in the past. One of the things that's encouraging, even though the numbers are high, one of the things that is encouraging is over the past 2-3 years, we have increased the training on one of the biggest danger signs for EV homicide, which is strangulation. The challenge for officers is trying to prove or get to that probable cause level for strangulation if you don't witness it, and if there isn't any apparent injury. So there is a list, and we trained our officers on what to look for and how to go through a process to identify that. And we've increased the amount of arrests that we made on second degree assault strangulation cases, which are really, really important for intervention at that stage before it becomes lethal. We also have a lethality assessment that officers are trained in. They ask a series of questions, and there's a scientifically backed methodology to those questions that allow DV unit and their partners to analyze and prioritize the level of threat that a victim's in. So it might be a minor crime, but because they go through that LAP card, that lethality assessment program, they identify things that didn't happen that day, but are happening in that relationship, and it allows them to intervene before it gets more violent. So we are working painstakingly on the domestic violence program and trying to reduce it in our community.
Thank you. Appreciate it.
Okay, any further questions? Sir, again, thank you very much for being here tonight. We really appreciate your time.
Thanks for having me. I appreciate it.
Okay, a lot of information, and we'll move on here on our agenda. Mr. Logue, you are going to talk to us about the OPO closing reports.
Yes, sir. And I told Assistant Chief Lundgren we'd probably take an hour of his time. So the fact we only took 2 is not too bad.
Has it really been 2? Wow.
I also appreciate you coming here. Louis May and I had the opportunity to go to a training, 2 different trainings. I went to one, she went to another on this very presentation. And it's overwhelming to sit through when you realize just how many changes are taking place right now. So I appreciate you giving that to us.
It's my pleasure.
You might want to stop sharing.
I'm trying. I am trying. Might have to leave and come back.
Maybe if I, let's see here.
Oh, here we go. There we go. I think that's going to work. Sorry. Technology is not my forte.
Okay, so we wrote three closing reports during this period since we saw you last, and the first one is going to be on F20028. I'm just going to show the title page. I'm not going to scroll through it the way we did last time, but the second. Can you see a Word document when I do that? Or just you see the Word document with the recommendations? Because that's really where the crux of all of this stuff goes today.
Do we have this, Mr. Logue?
Yes, ma'am. These.
I've got this one, but I don't see 028, but that's okay. I'm sorry, didn't mean to interrupt.
No, that's okay. They should all be attached to the agenda and the packet.
Okay, I'll look. Thank you. Sorry.
No problem. So we had F20028, and then following we had a F20049. We also did a closing report on a mediation case. And the reason we did that is because of the new collective bargaining agreement. It's the one type of case that is mandated to have a closing report. We brought that up before the collective bargaining agreement was signed, but it still made the final version. So we have written language for the city and the police guild to ask and see if they could change that requirement. And the reason we want it changed is that the mediations themselves are confidential. So it becomes difficult to write a closing report on something that's confidential. So we did put this together because it is a requirement. But I would expect that you will probably not see them in the future. But both of these use of force cases, thinking on what we just heard Assistant Chief Lundgren go over, these 2 cases show just how fast things can become really, really complicated. And this first one, 028, we did write this report with some of the new changes in mind. This incident occurred last year in July, and so all of these different changes, which you just heard about, were absolutely not the law or in place at the time. But this case is, we've informally recommended the police department to take this one as an example to look at and see how, if something similar might happen today, how would we need to do things differently moving forward to make sure that officers maintain compliance with all of the differing new laws. So F20028, it involved a level 1 and a level 2 lateral neck restraint, 2 attempts at a level 1, and multiple taser applications. And this went through a chain of command review. And then after that, it went to a use of force review board. And what happened was an officer was dispatched to a storage facility who had called in a suspicious person. And that suspicious person was in a red van in a parking lot. And it appeared that the person was living inside of it. So the officer arrived as a single unit. He didn't have backup at the time, and made contact with the individuals. The purpose for asking for the person's information was in order to enter them into the trespass database, which is maintained. One of the individuals did not provide the correct name, despite multiple attempts by the officer to clarify it. During that process, the individual took off running, and the officer pursued the suspect on foot. Multiple times throughout, I would say it's maybe a total guess, but 50 yards of a foot pursuit before they came to a chain link fence, which the suspect tried to go over, but the officer was able to pin them against the fence using body weight. And that's when the lateral neck restraints occurred. But multiple times during that short pursuit, the officer gave warnings to stop, or force might be used. He didn't want to use force against the suspect, et cetera, et cetera. But as the officer pinned that person against the fence, a physical confrontation definitely began. During this confrontation, the officer was struck in the face by the individual, and the suspect then turned and faced the officer directly. But what made it more interesting was that the other person who had been with the suspect originally, so there were 2 people in the van, was coming up towards the confrontation, and the suspect began asking that person to help them in their struggle against the officer. At that point, it changes the officer's focus. He could see 2 people coming up, and the suspect was able to break free from the officer momentarily and jump over that chain link fence. During that struggle, that physical confrontation, in which the officer was hit directly in the face, if you watch that, I was very surprised at the officer's reactions, because there were almost none. It was very conversational, kind of quiet. Why are you doing this? I don't want to do this. That kind of thing. Definitely de-escalation technique going through the entire time. It did not escalate even when the officer was struck. So the suspect made it over the fence. The officer gave command to stop, and then utilized the taser to immobilize the suspect. That caused the suspect to fall down and allowed the officer some time to get over the fence. But here's the thing with the taser. You know, sometimes on TV, you'll see a taser applied and it'll knock the person unconscious. That's not what occurs. It's a 5-second window where the body is immobilized during the taser application. Once that 5 seconds is over, that restriction on the person's body is now over, and the suspect was able to get up and move again, in which the officer used a taser then multiple times as he was closing in on the suspect. Several of them didn't seem to appear to work because the suspect was still able to move. But as the officer caught the subject, they and went towards attempting to arrest that person, there was still some physical resistance, and the officer ended up using the taser. You can use it in two forms. One's normal, which shoots out darts and hits you in two spaces, and the other is without darts. It's called drive stun, and that's just touching the taser to a person's body. And during that process, the subject was drive stunned, which is less than a 5-second application. It requires contact to be maintained 3 times before the officer was able to get that person into handcuffs. From the time the suspect took off running to the time handcuffs were applied was 3 minutes and 17 seconds, which is an awful lot of time to be in a physical confrontation by yourself. So when we looked at this case, we had already been a member of the Use of Force Review Board, and through that, we were able to go over what the chain of command recommended, and then come up with any recommendations inside of the review. We figured that there would be some community interest in this case simply because of the number of applications, but we also thought that it provided a great example of something that you've probably heard us say before, that we want tactical reviews, full tactical reviews of uses of force. So at the moment force is used, you can usually see an action that's readily apparent as to why the officer used force on the subject. When we talk about tactical reviews of that use of force, we're talking from the moment the officer got the call all the way up and all that time in between to see if there were other alternatives to that use of force. Some of the things that were noted by the chain of command in their recommendation for a finding was that the officer arrived by themselves and they did not have a cover unit. In those situations, the danger to the officer is significantly greater, and when officers do use force, they have a tendency to use a greater level of force to gain control, as compared to situations when multiple officers are there. The officer was alone, fatigued, at a size advantage. They acknowledged it's not ideal to use a taser multiple times, but it was very clear that the suspect continued to actively resist the officer and posed a threat to assault the officer at any moment, and had already assaulted the officer. In addition to hitting the officer in the face, the officer received a bite mark on their arm. But the focus of this report came down to governmental interest. The initial call was for a suspicious person and to trespass that person. It very quickly moved from that Terry stop to find out who it was to trespass that person to probable cause for arrest because of obstruction. And that obstruction would be when the the suspect failed to provide the officer their name. So when we talk about governmental interests, we're talking about weighing out the need for that arrest versus an individual's right to privacy. And those things are covered under the Fourth Amendment of the Constitution. So of note, since June, SPD has adjusted the way it responds to trespassing an individual. Before that time, you would see officers go to calls and a business would request that they trespass an individual, and the officer would fill out paperwork for that business and give it to the person and tell them that they're trespass. Officers will no longer do that. That is a transaction between the business and the person they don't want there, and businesses are required to handle that notice that the person is no longer welcome there, and that's not an SPD function. That being said, SPD still has a right or has the ability to arrest somebody that willfully is refusing to leave after being told that they're supposed to go. That would be a criminal trespassing charge. So if you think about the presentation that you just heard and all of the different restrictions placed on law enforcement, we have a trespassing call. An officer arrives alone, it escalates, and a taser is used approximately 7 times during this action. Because of that, under the House Bill, I forget the number off the top of my head, 1140, I think it is, 1040 or 1140, where officers are required to have probable cause before they use force now, not at the time, but now. At the time, they had reasonable suspicion that that person might be trespassing on that property, but the only probable cause that they had to do with the obstruction of the officer. And is the obstruction of that officer not giving that name important enough for the government, the intrusion on that person's right to privacy, to move forward with effecting an arrest? I think that it is just an excellent case for SPD to consider looking at the officer's actions with this particular case, not just the officer's actions, but everything to do with this case, to see if this same thing occurred today, could the same actions be taken? And I think it would be problematic under the new laws. So I think there's a lot of learning we can do by using cases as case studies, which is why we are a huge proponent of tactical reviews. When the review board gets this case, in a perfect world, we would love to have that review board look at it critically and then provide officers alternatives, if there are any, if the review board comes up with any, to things that could have happened, to give them tools for the next time. Instead of just saying in policy, out of policy, it really doesn't provide any feedback to that officer. And because the new laws are becoming more restrictive, where they want officers to use lesser means of force and exhaust all other means of force prior to using something, I think having a critical analysis of what occurred would be absolutely beneficial to that officer. So for instance, one example would be, don't go to these calls alone. Had 2 officers gone to this call, maybe that person would not have been able to run, and we would have stopped that force from occurring. It's what ifing it, but it is kind of a a review where you can look at, if we did things differently, if we used different tactics, could we have avoided this thing? At the end of the day, the suspect was never trespassed. So the original reason for the call that the officer went to, the person didn't even get trespass. However, there was an assault on an officer and that obstruction charge. But in and of itself, our first recommendation, which you see up there, number 9, is that we really focus on the review boards that critically analyze the officer's tactical conduct. You might remember this recommendation. We made it last year during our closing report, C19-040. Because of these recent changes, I think it just exacerbates the need for these really critical reviews of force by the police department. During the review, though, I'll just read this part real fast. The supervisor included an analysis of the force when they came up with their finding recommendation. The lieutenant above that person did not provide a written analysis, but focus instead on some photo logs. The captain provided an analysis, but he provided it in groups of force instead of each instance that force was utilized. So really, if there was 2 level 1s, there was a level 2 attempt, and 7 taser applications. There's 10 individual uses of force to really look at in one case. So what we've recommended is that SPD create a standard format so that supervisors are evaluating force in similar ways while conducting their chain of command reviews. So those were the 2 recommendations as a result of this policy or of this case. I want to remind commissioners that I'm not allowed to say it was good or it was bad or anything like that. We put the first 4-ish, 4.5 pages of these reports are all the restrictions placed upon us in writing these reports. But the learning that we can get from this particular case in and of itself, especially as it applies to the new laws, is just tremendous. So it was definitely worth the time to go through it and try to write a report on. So the second case was F20-049. And again, it shows how things become super chaotic. Oh, go ahead, ma'am.
Mr. Logue, I was going to ask, remind me, when on recommendation R21-9, where it says recommend SPD either update the function of their review boards. Can you refresh my memory on who would be on those review boards from SPD? Are there different people along the way in the chain of command, or is it just one, like one basic review board?
It's different people, but usually who you'll see on there is the head of the police academy. So right now that's Lieutenant Wool. You'll have at least one person from internal affairs, and that can vary whether or not it's going to be the lieutenant or either of the 2 sergeants there. The Director McConnell's usually on there. And then you'll have a couple of defensive tactics instructors that are either officers or corporals as part of that, as well as the academy staff. So they have 2 sergeants out there that are focused on in-service training, and they're looking for those reoccurring trends in order to base some potential future training on. So for instance, this might be a case that they might utilize in September when they're training these specific law changes to the officers. They like to base it on something that occurred, which helps that learning process go. So we try to get a variety of different viewpoints in there. And then, of course, Louis May or I are also allowed to attend the Use of Force Review Board. Okay. So the second one came as part of the Collision and Pursuit Review Boards, as well as a Use of Force Review Board. So it was in both of them. And you'll see on the front of that case, there's 3 or 4 numbers associated with it. One's a P, one's a C, and one's an F. So one's a pursuit, one's a collision, and then one's a use of force. And again, just how fast things can change when an officer arrives to a call. So this was a call of a domestic violence situation in which the officers had probable cause already to determine that a crime had in fact occurred. Some things that make the picture just a little bit more challenging is it occurred on October 31st during trick-or-treating hours. So there's a lot of people on the streets, a lot of kids out, and the suspect fled on foot. So a short foot pursuit occurred. By officers, which allowed, as they were chasing the suspect, and the suspect managed to circle around houses and fences and get back to where the officers originally made their first contact with them. At that point, he found an unlocked running patrol car, and the suspect decided to get into that patrol car and drive it away. Inside of that patrol car is a patrol rifle. While it's locked in a case, there is a way to gain access to that patrol rifle. And you have a person that's fled police. They've assaulted their partner in that domestic violence situation and is now stolen. I'm sorry, they did not. Yeah, fled and assaulted their partner, and they've now stolen a police vehicle with the patrol rifle on Halloween with a bunch of kids present and around. There were other responding units coming to the area, and the chase was on. It went down a back alley, and decisions were made very quickly where an officer decided to use their vehicle to try to disable the other vehicle by ramming that person or that vehicle. So they rammed the vehicle with the front of their vehicle into the front of the suspect's vehicle. The suspect then was able to back up, in which case he collided with a fence, a steel gate post, and numerous other trash cans in the alley and sped off, evading capture. So now we've also added more property crimes to this situation. The officers followed this person a little bit further, and then there was an opportunity to pin the suspect's vehicle, which was a police car, with the front, again, of an officer's patrol car. As a result of this, the person was pinned, but the officer was then windshield to windshield, so face to face with that suspect as the officer exited the vehicle. Because of that, because of all of those preceding things that were going on, the officer intentionally pointed their firearm at the suspect and provided verbal directions to that person, which caused the suspect to get out of the vehicle, and then he was taken into custody without incident. During this case, 2017 police SUV incurred substantial damage to the rear, front, and sides, and a 2020 police SUV also incurred substantial damage to the front and sides. So this is where we get to some of the things that Lieutenant Lundgren was talking about, or Lieutenant Lundgren, goodness, I demoted him like 4 times. I apologize if you're still watching. Assistant Chief Lundgren talked about regarding pursuits. SPD has a very restrictive pursuit policy already. And then this House bill will only make it a little bit more restrictive. And the reason pursuits are restricted because when a chase occurs, there's a substantial chance of unanticipated injury to the public. And with a lot of kids around, it just exacerbates it. There's just a lot more people walking around at the time. So what SPD policy says, it says it is the policy of the Spokane Police Department that pursuits are permissible only when the necessity for immediate apprehension outweighs the danger created by the pursuit itself. Officers may only initiate pursuits for the following reasons. That's where it gets very, very specific, making it already a very restrictive policy. And the following reasons are homicide, drive-by shooting, assault, first and second degree, burglary, first degree, arson, first and second degree, rape, first and second degree, robbery, first and second degree, kidnapping, first and second degree, or a warrant for the above crimes. So very specific instances where officers can initiate a pursuit. Excuse me. So then the other policies that we looked at had to do with pursuit and intervention or forcible stops, using the pit or using the vehicle as a ramming device, the ramming definition, but then also Spokane Police Department's Defensive Tactics Manual on exceptional techniques. So when we were reviewing this case, these were the things that came to our attention, and these were the reasons why we felt it deserved a policy and procedures report. So as we're reviewing the chain of command comments, here were some comments that were stated inside of them. The officer was technically in a vehicle pursuit, albeit extremely short. Another one was, while the pursuit was not within the strict interpretation of SPD policy, I view the officer's actions of pursuing the stolen patrol vehicle in order to attempt legal intervention as an exceptional technique. Another person said, the use of force was not in strict compliance with policy. And there was recommended training in regards to pointing that firearm in. And what SPD's practice is that they don't want officers to intentionally point in. We use something called the press muzzle theory. And that's when you have a firearm pointed down, because with so many different things going on, something might impact you, which might cause, if you're pointing directly in at somebody, an unintentional discharge of that firearm. So they want to avoid that, and they train to that as well. So the problem with having a policy that is very restrictive, but then calling something an exceptional technique, I will very quickly read what exceptional technique says. So in their defensive tactics manual, an exceptional technique is any use of force technique and fundamental that is applied or deployed by an officer of the Spokane Police Department, which is not described in this manual, will be deemed as an exceptional technique. So then the reason of exceptional techniques will be judged from the perspective of a reasonable officer on the scene at the time of the incident, and any evaluation of reasonableness must allow for the fact that officers are often forced to make split-second decisions about the amount of force that reasonably appears necessary in a particular situation, with limited information and in circumstances that are tense, uncertain, and rapidly developing. Well, I can definitely see in this case limited information, especially officers coming up that haven't seen everything that occurred so far, and a situation that's tense, a stolen police car with a stolen patrol rifle, uncertain. They're in a pursuit. The person's running. They're destroying property in the process, and it's rapidly evolving. You can see there's so many things that occur that an officer has to take into consideration before coming up with a particular action. So the end of the day on this is that over the last 5 years of doing this job, I would say one of the most significant concerns that I hear officers state is that some people are held to one standard and other people are held to a different standard. And when I think about policy and policing, it should equalize the standard of what officers are held accountable to. So if we would take a certain action in one case, we should probably take that same action in another case. And I would say since I've been here, there's been, I don't know, 10, 15, maybe more instances where pursuits were found out of policy. And in this case, the pursuit did not, I got to be careful how I say that. Some of the chain of command believed that the pursuit did not fit the strict definitions of SPD's policy, and they expected it to be considered as an exceptional technique. The problem with exceptional techniques is this: exceptional techniques apply to uses of force. They don't apply to pursuits, at least in SPD's policy manual. So the first recommendation which we made in this case is that they reevaluate the circumstances in which a pursuit may be authorized to eliminate that ambiguity for the officers, that they know exactly when and when they can't. Because if they say you can only do it this many times, but we're going to give an exception for this, what are the other things that we're going to give that exception for? So we want to reduce the ambiguity for officers. However, that being said, we also said it should ensure strict compliance with the provisions of House Bill 1054, which makes pursuits even more restrictive. So it's just looking at it and coming up with the specific, this is what is allowed and this is what is not. I also state in this recommendation is that SPD should also ensure an evaluation of the factors leading up to the pursuit to determine if the pursuit may have been avoidable, similar to what I'm asking them to do in uses of force. So in this case, they have a foot chase. The person circles around and finds an unlocked and running patrol car. Maybe we tried to have the city invest in something where when an officer's outside of a vehicle, the doors will lock automatically, or something so that that person doesn't have as easy of an access to that vehicle. But I also understand that when you're arriving quickly on a scene and you see somebody take off running, your focus can very quickly switch over to, I got to catch that person. And maybe you don't think about putting things in park, turning off keys, taking keys with you, all of those things which would have prevented that pursuit from occurring to begin with. But if we ignore those things and we don't talk about those things, we're not teaching or providing those learning opportunities to our officers. And as policing becomes more and more restrictive, it's important for us to consider all of those things which might help to avoid a pursuit, a collision, or a use of force. And then again, in recommendation 21-12, I recommend eliminating exceptional techniques. And what I heard Assistant Chief Lundgren state today is that by definition, some of these new House bills or these new laws are going to eliminate exceptional techniques in and of themselves. Because we looked at Seattle Police Department's use of force policy, which is over 100 pages long. It's very obtuse. It is just very big, but it lists everything that an officer is allowed to do inside of the Seattle Police Department when it comes to force. But that reduces the liability on the department and then the city after that for any actions that an officer takes that might be outside of that. SPD has more of a liberal interpretation and allowance for different techniques, or at least they did, and that's changing with some of these new laws. Whereas we couldn't possibly train all the different techniques which could be utilized in a physical confrontation. And I understand that, but we do recommend that we don't have exceptional techniques, and that if something is out of policy, it's out of policy. If it's in policy, it's in policy, whichever they decide it to be. And those are the recommendations based on these two reports. The mediation report did not have a recommendation inside of it. Are there any questions?
Just a comment from me. Having received the training from the assistant police chief, Mr. Lundgren, and then listening to these two reports and your recommendations is really telling and really interesting application of what we've heard tonight, and now we're seeing it in a real situation and how these House bills can affect the outcome or make an agency think twice about what is correct and what isn't. I appreciate the narratives that you provided, and I wholeheartly support the recommendations that you have come up with, you and the other office members, and I think a job well done.
Thank you, sir.
Any other comments? I do believe we need to make a motion to accept these recommendations, or to, is that right, Mr. Logue?
Yes, sir.
So I would entertain a motion to adopt these recommendations.
I will make the motion to adopt these. I believe there's 4, correct? Recommendations.
Yes, ma'am. Would you like me to put them back up on the screen?
Oh, I have them right here in front of me. So
Okay.
they're very well explained, Mr. Logue. So I make the motion that the OPOC approves these recommendations.
I'll second it.
Okay, all those in favor of adopting these recommendations as written in the reports, please indicate by saying aye. Aye.
Aye.
Aye.
Okay, the recommendations have been approved by the commission. Again, thank you. And so commission business item number 2, training, NACOL annual conference and ride-alongs. It is getting late, so I'm going to kind of briefly go through some of these things here. The NACOL annual conference, there's one that's in live in person, and that is in December in Tucson, Arizona. I believe it's mid-December. But And also, we have a great opportunity to attend a virtual NACOL conference. And just a reminder that NACOL is kind of the big kahuna when it comes to police oversight, and an organization in this country that advocates and that trains civilians such as ourselves, and really is at the heartbeat of police reform. You cannot do better than to try and participate in some aspect of NACOL. It is a rich and rewarding experience. These opportunities are available to all the commissioners. The least expensive and the most flexible version is the virtual, and thus far we have 5 commissioners, and 2 commissioners have accepted the invite to view some of the NACOL virtual conference sessions. The good news on that is that you can, these sessions are archived and available for viewing at your time and place up through, I think, about mid-October. So I can't say enough about how important this organization is. And also, the in-person in mid-December is open for a commissioner or 2 to attend if they wish, and you would need to make your wishes known to Christina, who can make those arrangements for you to travel to Tucson and be a part of that event. So I think I've, and also if you have not yet signed up for the virtual version, it's not too late. They started the sessions this week, but again, our tuition fee allows us to view the videos or the sessions up through October at our with flexibility. Coupled with this item,
Commissioner Smith.
go ahead. Yeah.
The sessions that will actually be the live sessions will go through October, but you'll be able to view the sessions up until December 31st. So it's not
December
something
31st.
that you have to, it's not something that you have to watch live. You can view them at any time before the end of the year.
Thank you for that clarification. I appreciate that. Also, there is an event in Connecticut in late November, early December. It's about a 3-day training on the use of force. And Mr. Logue, if you can help me on this one, I believe it is conducted by or put on by a police agency in that area. And they discuss uses of force. And do you want to add, in a nutshell, more information on that, Mr. Logue?
Sure. It's put on by the Daigle Law Group, and attorney Eric Daigle is one of the attorneys for the International Associations of Chiefs of Police, and he is a frequent presenter at NACOL in regards to trying to reduce liability inside of police departments. He does look at force from a liability standpoint on the city and the department, and then an officer as a whole. But he does speak to officers. It's mostly attended by police agencies and officers, and so he discusses it from their point of view. That being said, he still puts out those opportunities to avoid force and those sorts of things. So it's really, really informative. we were able to attend it virtually this last year. And again, like with NACOL, because of that, I was able to go through every single session. And he just talks about case law and liability and how to avoid it from every aspect of force that you can imagine. There was probably 40 different sessions in regards to force that were offered.
Okay. Okay. Thank you, Mr. Logan. So any commissioner who might be interested in that event, please let Christina know. I know that in a previous commission meeting, we kind of put a damper on any ability to have commissioners travel anywhere due to budget constraints. But it turns out, upon closer review and maybe a bit of shifting in the budget, I might be wrong on that aspect, but that there is actually funds to send one or two people to either one of these events. So please think about that. Ride-alongs is also attached to Commission Business Item number 2, a friendly reminder to fulfill our obligation to do at least one ride-along a year. And again, if you talk to Christina, she will get that set up for us. I'm beginning to wonder with the Delta variant and COVID whether there might be changes. I'm just speculating. I have no evidence that that's going to change anytime soon, but just curious. And then we're going to move on to Commissioner Speak Out. My brain's a bit mushy right now. It's been a long evening. I guess as chair of the commission, it would be within my scope to mention the importance of all commissioners attending as many, if not all, meetings as possible. It feels like we're getting closer and closer each time we have a meeting. The question is, do we have a quorum? I don't like to see us at that possibility that we don't have a quorum. I think being a commissioner is a full responsibility, not kind of a part-time when we feel like it. I know I'm being a little blunt here, but it begins to feel heavy on one or two commissioners fulfilling the obligations when it really should be a 5-commission helping each other fulfill the mission. And as to why we're even on the commission, I would just ask that we all think about that, and I'll stop there. Any other words of from other commissioners?
Jenny, I'm Jenny here, Commissioner Smith.
Mm-hmm.
I was gonna get on what you just said about being committed to this commission. I know that our OPO, Louis Maybard and Christina, sometimes sends emails and then they get no response or they get no commitment. For instance, the Unity in the Community is this Saturday. And actually, ideally, all 5 of us should be signed up for that. Ideally, this is our one chance to get out there in the community and talk to people. And for the past 2 or 3 years, it's been the same commissioners going there. So I just want to encourage people to, look at these opportunities were presented. Last year, we had no Unity in the Community because of the COVID. And I just, I appreciate everybody being here tonight. But we just, this is a commission that we need to be really, really committed to. It's just not a haphazard thing, and it's a little frustrating. I'm going to be honest, in my personal opinion. And I get a little bit like when I sign in and I don't see, are we going to have a quorum tonight? That shouldn't be anything in our minds. We either have a quorum or for unexpected reasons, we don't. If people can't make the meetings, they need to let Christina know long before a meeting starts, unless it's a major emergency. I get emergencies, those happen. But it just seems like we're just barely meeting the quorum every time we meet. And I just want to, encourage people that this commission is a lot more than just showing up. It's being involved in it. So, thank you for listening to me say that tonight. I really appreciate it.
Okay, we're missing two commissioners. We have Mr. Jasmine, Commissioner Jasmine. Anything that go to the order for our speak out?
No, I mean, I guess yes. I hear both of you loud and clear, and as one of the newest commissioners, I will take that into account for myself and just look at more opportunities to be able to engage. So I appreciate the call out for us to participate more and be more involved, and I look to do my part. So
Okay.
that's it. I appreciate the
Thank
work
you.
that everybody does.
Yeah, thank you for that. And unfortunately, we got two commissioners who aren't hearing the message. I will figure out some way to get that message out to the other commissioners and myself. I know I've got my own goals that I need to think about in my participation. I am certainly not the angel here by any means, and sadly, I've never have been to the Unity in the Community, and so I signed up for my first time this Saturday, and I'm really excited. And so I too had to remember, there's a lot to this, and it's all worthwhile. It really is. And my last word is Nicole. Just really think about that aspect. Okay, so and then our very last item is September meeting discussion. It appears that a couple of training opportunities for the OPO staff are happening right around mid-September or before we normally meet. So suffice to say that it really creates a challenge to be ready for a regularly scheduled meeting, which of course is in September. And so the short version of what I'm trying to get at here is we likely need to cancel the September meeting due to trainings happening. So is there anyone here opposed to that cancellation? Okay, so.
Sorry, you
do
couldn't
we
see
need-
my head shaking. No.
Oh, yeah, sorry,
Not
I can't
opposed
see
to it.
anything. Yeah, not opposed. Mr. Commissioner Luke, I'm sorry, I do mix up your names sometimes. I apologize.
You can
Commissioner-
call me Commissioner Luke, man. It's all good.
Okay, all right, sorry about that. Any opposing view on that?
I don't.
Okay, so let's go ahead. Do I need to make a motion for that, or is it just okay?
Yes, sir. If you make a motion and then everyone will vote and we'll go from there.
Okay, I'll
Correct.
entertain a motion that
Sorry, Tim.
we. I'm sorry, I'm not hearing the voices that just came over. Okay, I'm gonna go ahead and proceed. My apologies if somebody already made a motion. I need entertaining a motion to cancel the September meeting.
I'll second.
Okay, all those in favor of canceling the September 2021 meeting indicate by saying aye. Aye.
Aye.
I need to hear from Jenny, I think.
Sorry, I was muted. Aye.
Okay. It is now official that the September meeting is canceled, and we will reconvene in October. And thank you for hanging in this evening. It was an especially long meeting, and but I think we really gained a lot from the Assistant Chief of Police, Mr. Lundgren, and also from Mr. Loeb's recommendations. And so anyway, thank you very much. You all have a good evening, and we'll see each other soon.
Thank you, everybody. Thank you.
Good night.
Thank you.
Thank you. Good night.